Hello everyone. Today I'm going to talk about the issue of application of RTI on Supreme Court. So this issue has been in news recently. It was referred to a constitutional bench way back in 2010, and in 2016 it was referred to the constitutional bench again, and finally the apex court has decided to take up this issue and give a judgment if the Supreme Court is subject to the RTI Act. In this video, we'll see how this issue arose and what are the arguments for disclosure and against disclosure, as well as what was argued in the court. So the start of the issue. In 2007, Subhash Chandra Agarwal filed an RTI petition to know if the judges of Supreme Court and High Court have released information regarding their assets to the Chief Justice of India. Now this petition was keeping in mind that in 1997 the Supreme Court had asked that all the judges of High Court and Supreme Court should disclose the information of their assets to the Chief Justice of India. Okay. Now, when this RTI petition was filed, the court did not give the reply to the applicant, and hence the applicant went to the Chief Information Commissioner. Okay. And the Chief Information Commissioner directed the Supreme Court Registry to furnish this information, as Supreme Court was a public body under RTI Act. Okay. Now, the Supreme Court challenged this order of CIC in the High Court, and a single judge bench was constituted which upheld the order of Chief Information Commissioner by stating that the Supreme Court is a public authority under RTI Act Section 2. Now the apex court again filed a review petition in the High Court, and a 3-judge bench was constituted which upheld the judgment of the 1-bench court. Okay, so it stated that the applicant has not asked what are the assets of the judge, but has only asked what all judges submit their asset to the CJI. And this information does not relate to any personal matter, and it's also not in fiduciary capacity. By fiduciary capacity, it means a confidential issue. Like what are their assets can be a confidential issue, but have they disclosed their assets to the CJI is not a confidential or fiduciary issue. Okay. Around the same time, the applicant filed another petition asking about the details of exchange of information between the collegium and the government regarding appointment of certain judges to the Supreme Court. Okay. Now this worried the court, especially because CIC upheld this by stating the 3-judge bench judgment, and hence the court then decided to refer this issue to a constitutional bench. Okay, now this happened in 2010, and finally after 9 years a constitutional bench was created. Okay, at that time 3 key issues were identified. Number 1 was, will disclosure of such information affect the independence of judiciary, affect the functioning of judiciary? The second issue was, will the collegium be able to discuss the matter frankly and freely regarding appointment of judges? And if they are not able to take this decision in a frank and free manner, the decision might not be optimum. And the third issue was whether the information sought is exempt under Section 81J of RTI Act. Section 81J exempts certain information that relates to personal character of a public officer. On behalf of petitioner, it was argued that in the SP Gupta case, also known as First Judge's case, the court held that open and participatory democracy requires accountability and access to information to the citizens. Okay, it will create a stronger democracy. The court also stated that since the matter of transfer of judges is of very high public interest, thus such disclosure will not be detrimental. That means that the information related to transfer of judge, if it's disclosed, it won't be detrimental to the institution of judiciary. Okay, and it will only be in the interest of public, as it will bring in accountability in the judiciary. Now, if transfer was an information in public interest, so is appointment of judges to Supreme Court and High Court. Now, the second argument was that even internationally and through various cases in our own history, the court has held that right to information is a fundamental right of every citizen. Okay, it enables a citizen to make informed choices. Okay, and finally, constitutional experts, eminent jurists such as S.P. Sate, they stated that right to information is also an inclusive part of Article 14 and 21, as it helps against the discriminatory or arbitrary action of state. Because if you have the information, then only you will be able to know if the action is arbitrary or not. Okay, so these were the three major points put up by the petitioner. Coming to arguments for non-disclosure, it was argued that if the judges knew that whatever is being discussed in the collegium might come out in public under RTI Act, they might not be able to discuss their views opinion as frankly as they would otherwise. And this might hurt the appointment process, as it won't be optimum. The second argument put forward was that any such disclosure may have an adverse effect on a judge's reputation, their personal life, or their family life. Now, in this case, the court cited the example of a Madras judge. He was a district judge who was being considered for appointment to High Court. However, the said appointment didn't take place, and the reasons for his rejection came out in public. Now, due to this, what is a norm for district judges that at the age of 58 they get 2-year extension, this judge did not get it. While the other judges, other district judge of Tamil Nadu, who were not even considered for appointment to High Court, they got this extension. So this definitely shows that if information related to the discussion in collegium comes out, it might affect the professional life, the reputation of the judge. Now further, the discussion also involves some personal information, because every sphere of their life is scrutinized. Okay, so information which is personal, which shouldn't be out in public domain, might also come out because of RTI, and then this would again lead to adversely affecting the reputation of the judge, adversely affecting their personal life. For example, it was cited that if the wife of a said judge is schizophrenic, okay, now the judge, this, like, public shouldn't know this, public has no need to know this, but the judges will still discuss this while they are talking about the appointment of the said judge to High Court or Supreme Court. And last, it was argued that the S.P. Gupta case, the judgment there was very idealistic, as well as it was given prior to the enactment of RTI Act. Now the impact of this is that since before enactment of RTI, such a disclosure can only be sought by the aggrieved party, that is the judge who was rejected. That means that if they want, then only the collegium discussion would come out. Now, however, any person, any third party under RTI can ask for this information. And as argued already, that the collegium discussion would involve some personal information. So earlier, The judge knew that if he wants this information on discussion to be made public, they know that what kind of information would come out, and they know that their personal information would come out. However, if a third party files for RTI, the aggrieved judge who has been rejected, they are not even involved, they are not even asked their opinion if they want such personal information to be released in public. Keeping this in mind, the Supreme Court decided to reserve the decision on this matter. Now, reserving the decision means that the Supreme Court said it will analyze the evidence, the proofs further, and then at a later stage give out a written order. Okay, a detailed written order will be given out later. However, the court did state that there cannot be a blanket ban on such disclosures, and such disclosures cannot be made automatically under RTI. Okay, they will analyze the merits of the case and then decide what is to be done. Okay, and the argument for this was the same. We discussed it in the last slide, that such information can be of personal nature, such as sexual orientation of judge, medical condition, etc. And these cannot be disclosed without analyzing the merits of such disclosure on public interest. Okay. The second reason given was there needs to be a balancing in the openness to public life. Like, absolute openness cannot be guaranteed, because you never know what will happen in absolute openness. Everyone has some private information related to them which they don't want to be disclosed, and which is not necessary to be disclosed in public interest. Even Article 19 has reasonable restriction. RTI Act has some exemptions. So there is a need to balance, and thus we cannot go for absolute openness in disclosing such information related to discussion. The court, however, did point out to the fact that knowing that the discussion would be made public, this will not hamper free and frank discussion of their opinion, because the Chief Justice of High Court, Chief Justice of India, they are not made of weak stuff. The court has not given the final decision on the matter. However, the current position makes it quite clear what direction the court is taking. And I think the entire topic that I've discussed should be enough. If any question related to RTI on Supreme Court comes, you can talk about why there should be openness. Then you can talk about the arguments against such openness, and then you can finally conclude by giving the court's opinion. You can even cite the example of the Madras District Judge Court. Thank you everyone. Have a nice day.